Nothing gets the room quiet like a bunch of judges walking. All right. Well, hello, everyone. Good evening. My name is Jessica Dusick. I'm the chair of the Moot Court Executive Board, and it's my pleasure to welcome you to the 31st Annual John W. Davis Appellate Advocacy Competition. This year's competition involves a fascinating and very relevant constitutional question involving the limits of our First Amendment rights. The finalists, Roddy, Flynn, Jacob Triolo, Suzanne and Steve Harkins, have distinguished themselves as the best appellate advocates among a field of over 70 competitors. We have no doubt that you will be as impressed by their intelligence and poise as we have been, and we look forward to their performances tonight. The finalists have thrived in the face of difficult questions by the Moot Court Board, who judged the first 3 rounds of the competition. And the finalists also successfully combated the questions of the semifinal judges, who were professors and active judges themselves. But now the finalists face the most prestigious bench in the history of this competition. And it is my honor to introduce to you some of this competition's bench. The Honorable Bobby Ray Baldock currently serves as an appellate judge on the 10th Circuit Court of Appeals. He graduated from the New Mexico Military Institute before attending the University of Arizona Law School. After law school, Judge Baldock and his wife Spunky moved to Roswell, New Mexico, and he practiced there and eventually became a partner of the law firm Sanders, Bruin, and Baldock. After 23 years in private practice, President Reagan appointed Judge Baldock to the United States Court of Appeals for the 10th Circuit. In addition to serving on the Court of Appeals for the 10th Circuit, Judge Baldock has also served as a member of multiple committees of the Administrative Office of U.S. Courts, and he has also served on the United States Foreign Intelligence Surveillance Court Review at the request of the late Chief Justice William Rehnquist. Judge Baldock currently resides in Roswell, New Mexico with his wife Spunky. The Honorable Dwayne Benton currently serves as an appellate judge in the 8th Circuit Court of Appeals. Judge Benton graduated from Northwestern and then attended Yale Law School, where he was the managing editor of the Yale Law Journal. After graduating from law school, Judge Benton was a Judge Advocate General in the United States Navy, during which time Judge Benton earned an MBA and a Master's of Accounting from Memphis State University. Judge Benton also earned his LLM from the University of Virginia, and will be expecting his PhD shortly. Judge Benton entered private practice in 1983, before serving as Missouri's Director of Revenue from 1989 to 1991. And in 1991, Judge Benton became a justice of the Missouri Supreme Court, and he served as Chief Justice of that court for 2 years. In July of 2004, Judge Benton became a judge on the United States Court of Appeals for the 8th Circuit. Judge Benton retired from the U.S. Naval Reserves after 30 years of service. In addition to serving on the bench for the 8th Circuit Court of Appeals, Judge Benton is also an adjunct professor at Westminster College and the University of Missouri School of Law in Columbia, Missouri. Judge Benton currently resides in Kansas City with his wife, Sandra. The Honorable Jennifer Walker Elrod serves on the United States Court of Appeals for the 5th Circuit with chambers in Houston, Texas. Judge Elrod is a Phi Beta Kappa graduate of Baylor University and graduated from Harvard Law School, cum laude, where she was an Ames Moot Court finalist and the senior editor of the Harvard Journal of Law and Public Policy. Upon graduating from Harvard, Judge Elrod clerked for the Honorable Sim Lake of the United States District Court for the Southern District of Texas. Judge Elrod entered private practice at the law firm of Baker Botts before being appointed judge of the 190th District Court of Harris County, Texas. And after 6 years presiding over the District Court, Judge Elrod was appointed to the 5th Circuit in 2007, only 15 years after she graduated from law school. Judge Elrod has received numerous recognitions for her achievements, including 2 President's Awards from the Houston Bar Association and the Judge Thomas Gibbs Gee Award for her pro bono work. Judge Elrod was named the Woodrow Seals Outstanding Young Lawyer of Houston and Judge of the Year by the Mexican American Bar Association of Texas. Judge Elrod is an elected member of the American Law Institute and serves on the board of directors for the Texas Center for Legal Ethics. Judge Elrod was in Lexington this past spring to present the Lewis F. Powell Jr. Distinguished Lecture. And Judge Elrod currently resides in Houston with her husband, Hal. Please join me in welcoming all of the judges to Washington and Maine. And now the administrators of the Davis competition, Margaret Hannaful and Rachel Vargo, will explain the structure of the Davis competition and this year's problem.
Hi, I'm Margaret Hannaful.
And I'm Rachel Vargo.
And we are this year's Davis competition administrators. John W. Davis is perhaps one of W&L's most famous alumni. He graduated in, I don't know when. He was a Temple General. He graduated both from the undergrad side in 1895 and then from the law school 3 years thereafter. He was born in West Virginia. And among his many accomplishments, he was a senator, he was a solicitor general. He rejected an appointment to the United States Supreme Court so that he could continue to argue in front of it. He was an ambassador to the Court of St. James. The reason we've named this competition after him is because he argued 139 cases before the United States Supreme Court before his death in 1955. At that point, that was a 20th century record. In addition to his fine appellate work, he gave an address about the 10 points for appellate argument, which has been handed out in bar associations, appellate competitions, and classes since it was first delivered, and it continues to be a 10 commandments of appellate argument for oralists today. This year's competition started with 74 competitors, whittled down to the 4 you see in front of you. Every competitor wrote a brief, argued both on and off brief before they were cut to the 16 quarterfinalists, then the 8 semifinalists. Our professors, Professor Professor Massey, Professor Belmont, and Judge Forrester made the decision to cut from the semifinalists, the 4 you see before you. And we're sure that we're in for a really good round tonight.
This year's problem is loosely based on the case of Snyder against Phelps, which was argued before the Supreme Court earlier this month. The problem centers around the issue of the tension between First Amendment protected free speech and the ability of the states to protect their citizens from harmful speech through tort law statutes. Marine Lance Corporal Andrew Keatley was killed in the line of duty. His father, the petitioner, Mr. Benton Keatley, scheduled his son's funeral at St. Rodney's Catholic Church in the small town of Las Vegas, South Virginia, and posted an obituary in the newspaper. The respondent, Mr. Andrew Finicum, is a founder and pastor of the Sidney Lewis Church of God in Leestown, West Indiana. Members of Mr. Finicum's church have strong anti-homosexual religious beliefs and often picket funerals of members of the military in order to spread these beliefs. Mr. Finicum and his daughters learned of Lance Corporal Keatley's funeral and announced that they intended to picket the funeral. Abiding by all police directions and local ordinances, the Finicums set up a protest directly across the street from St. Rodney's Church at the time of Lance Corporal Keatley's funeral. At this protest, the Finicums held up handmade signs that carried anti-military and anti-homosexual messages. Mr. Benton Keatley and other funeral goers saw these signs with their highly offensive messages and heard the highly offensive chants of these figures. Mr. Keatley had an extreme emotional and physical reaction to the protest at his son's funeral. His physician confirmed that Mr. Keatley's depression and diabetes have worsened significantly, and his psychiatrist stated that the protest prevented Mr. Keatley from proceeding through the appropriate stages of the grieving process. Ultimately, Mr. Keatley sued the Finicums and the Sidney Lewis Church of God under 2 South Virginia tort statutes: intentional infliction of emotional distress and intrusion upon seclusion. The district court found in favor of Mr. Keatley. The circuit court overturned the district court's verdict. The Supreme Court of the United States granted certiorari and will now hear oral arguments in this matter. Thank you.
So at this point, we're going to take 2 of you out of here, and you all...
Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and the Honorable Court.
Please be seated. Good afternoon, ladies and gentlemen. I assume that in the back of the court you can hear us. At this time, without further ado, we will hear you in case 101985. Counsel for the petitioner, you may proceed.
Yes, sir. Mr. Chief Justice, and may it please the Court, my name is Anthony Flynn, Jr., and I represent the petitioner Benton Heatley in this matter. With respect, I'd like to reserve 2 minutes for rebuttal.
That's up to you.
Thank you. Your Honors, this is a case about privacy, about the right of an individual to mourn the passing of a loved one in solace and solitude. And when that solitude is broken, the right of a state to provide the appropriate avenue of judicial redress. The trial jury's verdict of $3 million should be reinstated for 2 reasons. 1, as a private person, the petitioner should not be held to the actual malice standard laid down in Hustler against Falwell. And 2, as a funeral is a private event, the petitioner was a member of a captive audience, and therefore the jury had the law and the facts on their side when they determined the petitioner succeeded on the intrusion upon seclusion claim.
Counsel, how about in the Falwell case, why shouldn't your client be held to the same standard as if it were the public? Because the jury can draw the same or have the same subjective thoughts or draw the same subjective conclusions from the facts. So why should it not be the same?
Your Honor, the Hustler court turned on the fact that the Reverend Falwell was an undisputed public figure. And the state has a weightier interest in protecting the privacy and exercising their police power when it comes to a private figure such as the petitioner. In Gertz, this court held a definition for what is a public figure. And part of that definition was a public figure is someone who puts themselves out into the common discourse and seeks to influence the outcome of a debate.
Well, counsel, so far you act like the Court of Appeals didn't rule in this case, and I think you know what the import of their ruling was. There are some types of speech to which state tort liability cannot attach. They read the Milkovic case that way. What's wrong with theirs that if it's not actual facts, they get to say what they want to say?
Your Honor, with due respect to the lower court, what they are attempting to do is create a categorical exemption for certain kinds of speech. That if speech is rhetorical hyperbole and touches on a public issue, it then necessarily is completely excluded from any kind of tort action. And this court has held previously in Woolston against Reader's Digest that outrageous, intentionally harmful attacks should not receive First Amendment protection just because they touch on matters of public concern. The lower court went too far here in creating this categorical exemption, citing Milkovich heavily, but Milkovich also stood for the proposition that courts should not create categorical exemptions, but should rather, as this court did in Dun and Bradstreet, look at the entire context of the conduct of the speech, how it affects both sides, the intent, so on and so on, and that should be what the jury is considering, and what the jury did consider in this case. When it comes to this balancing of state interests, we're dealing with a very traditional role of a state to engage in its police powers to protect the health and the welfare of their citizenry. So the state passed 2 statutes in question today, the IIED statute and the intrusion upon seclusion statute. Those statutes have very high burdens for the state to prove in order for the jury to find for the plaintiff. It's not as high as actual malice, the petitioner concedes that, but it's arguably the second highest standard available. Outrageousness that shocks the conscience, that is intentional or reckless. That's the IIED.
Isn't shock the conscience a subjective test?
Looked at alone it is, but when you go both with the outrageous standard and particularly the intentional or reckless standard, that's what stops an organization from accidentally falling backwards into tort liability. The actions must be intentional or reckless, and that's what raises the bar and still gives due protection to the First Amendment rights of would-be protesters. So the state, because they're dealing with a private individual, do have the right to set a lower standard than actual malice, which is what this court held in Gertz specifically, that states can set their own standards, and specifically holding that the standards can be lower than actual malice, which is what the state did in this case.
Well, in this case, didn't the father run an obituary in the paper? And does that not smack of a publicity seeking, even though that it's a obituary? Does that fact alone make that person a public, either a public speaker or in the public realm?
Your Honor, the petitioners contend that no, it does not make someone a public figure to simply run an obituary. This court held in National Archives against Favish that funerals are sacred traditions. This is in dicta, but funerals are sacred traditions of our civilization. And running an obituary is a traditional part of a funeral. It's announcing a mourning. It's not inviting public comment.
If it's not inviting the public, then why does it have the time and date and place of the event for the entire community? I thought that once you know the time, date, and event of a funeral, you could go to any funeral if it's in the paper.
Certainly, it's inviting the public, but it's not inviting public comment, and not an invitation.
Doesn't the public necessarily bring their comment along with them?
They may do so, but looking at the time, place, and the manner in which the respondents chose to attend this funeral, they didn't cross into the church itself, but chose to be picketing directly across the street. This content-neutral tort laws of this state provide for an appropriate jury to look at the totality of the circumstances and determine whether there was fault on the respondents, and they determined that there was.
Did the jury actually determine this? Did the jury make a factual finding that it was a private event, or did the jury make a factual finding that maybe it was a private figure?
They made a factual finding in the intrusion upon seclusion claim that there was a privacy interest, because part of the tort is that you intrude upon the solitude or seclusion of others. So that it wasn't an element given to them, is there a privacy interest in a funeral? But implicit in finding that there was solitude and there was seclusion that was breached is an implication that the jury looked at the totality of the circumstances and concluded that the petitioner had this privacy interest.
So wouldn't a reasonable person find any disruption or protest at a funeral, regardless of the issue protested, to be highly offensive? And does that mean that all funeral protests are naturally prohibited under the South Virginia Code?
Sure, Your Honor. It would depend on the totality of the circumstances and how the protesters were comporting themselves in that moment.
Don't we chill a lot of speech that way? By having these really vague standards?
Your Honor, the privacy interest in the intrusion upon seclusion claim is necessarily broad. And it would be unreasonable to expect a legislature to indicate every single instance where there might be a privacy interest, so they don't enumerate funerals specifically.
Can they hold up signs at the funeral that just say, "I'm against the war"? Is that okay?
That may not come under the intrusion upon seclusion claim. A fact that was very important in the intrusion upon seclusion claim was that the respondent's chants of "God hates fags" could be heard within the church as the service was proceeding. That's exclusively with intrusion upon seclusion, but it's an important fact for the jury.
So if this was just a sign case, you wouldn't be bringing the claim?
Certainly we would still be bringing the claim if the petitioner felt that his privacy right of the funeral had been violated. This court has held before in Hill against Colorado and in Frisbee that there are interests that just implicate picketing across the street from a residence, for example, even without shouting. The state still had a right to put limitations on that kind of picketing. In Hill, it was a medical center, a family planning center. The state could set limits and could have liability for people who were picketing outside of that medical center. So there is some precedent. It's never been extended specifically to a funeral, but there is precedent for the same line of legal reasoning.
Has it ever been extended to any other public place than a medical facility?
A public, not the home and a medical facility.
A public place, a church that has an announcement in the paper of when the event is. Has there ever been to any kind of public place?
This court has never held such, no. However, lower courts, which this court is obviously not bound by, but the Sixth Circuit held in Phelps-Roper that a funeral does have that kind of privacy interest, that it would be unreasonable to expect a mourner to not attend the funeral of his son out of fear of a protest. And when you're entering a church and you have protesters 50 feet away from you, you can't just turn your head and close your ears away from their shouts. What's important in this case is not what the respondents were saying, but the way in which they chose to comport themselves at their protest.
If you were going to, I'm sorry.
No, you go ahead.
If you were going to advise the respondent as to what they could do, what could the respondents do to not run afoul of this?
Under these tort claims, I would advise the respondents to not be within visual sight of the mourners of the funeral and to not have any chants which could be heard within the church.
Well, Chuck's a lot of small towns. They take the hearse all over town. They go by the high school, they go by here, they go by the Little League ballpark, so they can't even be in the town, right?
They could be in the town. That floating bubble of privacy is very different than one church that the respondents purposefully targeted and sat outside of. That's different from a hearse that travels or going to a large park for a burial or a scattering of ashes.
So that's the exception? If it's a floating bubble or if it's a hearse that goes all over town, is that an exception then, and that they can stand up and shout along the way or just hold up their sign?
Well, if they were following along, that may implicate other torts. However, the best decider of these facts, with all due respect to the wisdom of this court, is a jury, someone who represents the mores of a community, and there's a high enough standard in the statutes as stands that the jury will not make a content-based determination as to the funeral, as to the protests outside the funeral, but would rather make a determination based on the time, the place, and the manner of that protest.
So you have to wait till after the fact to find out if you're going to be sued for $3 million.
Well, there's
So
certainly...
you don't have any advice that would tell the person how their First Amendment rights can be protected.
I would say certainly not being in sight of the church would not implicate these statutes. That was certainly one way to do that. Second of all, a protest that doesn't target an individual, as they did here. They targeted Lance Corporal Keithley. They're having signage that was a lot more general and not screaming or shouting.
Well, now, counsel, the Court of Appeals, you're not giving them credit again because they split off one group of signs from the other group of signs and say the first set of signs, you know what I'm referring to, I won't burn your time that way, but they say the first set of signs only talk about matters of public concern. Why aren't the first set of signs safe?
The jury, with the Court of Appeals, as I mentioned before, it makes this categorical exemption.
Address the signs. You led us here by your very argument. So address, if they had just held up the first four signs, you know what I'm referring to. They're okay, right? By the arguments you just made.
If they had still been chanting and still all the other facts were the same, you still have a targeted protest. They didn't just happen to be across the street in the public park. They were there because they chose this funeral and chose to target this funeral. If you take out the two signs that refer to Andrew specifically, you still have other signs that a reasonable person could look at and conclude were targeted at the deceased. For example, God killed you, Marine Corps gauge should
Counsel,
die.
you've gone to the B part of the opinion. I'm trying to get you in the A part.
Oh, the God condemns homosexuals.
You know the first four there. You know the four I'm talking about in the A part.
Those ones would, if it was just those signs and there was no chanting, it would be a closer call.
So this freedom of speech you can't speak in, right?
You can speak in as long...
No, you're letting us do signs, but you can't talk.
You can talk if it's not heard within the church. But the best decider, I mean, these are complicated facts. There are lots of different angles to come at, and the best person to decide that is a jury, as long as they have the appropriate standard by which to judge it. And intentional, outrageous behavior is an appropriate standard when dealing with a private individual.
Well, how do you know who the you is then in the sign? It could be they're just opposed to the American society. Instead of God hates you, you could be the Society of America.
Your Honor, I see my time has expired. May I briefly answer your question?
Please.
The jury would look, as a reasonable person would, both at, as a kind of a helicopter view, of both at the respondents and their intentions, the petitioners and their reaction, and how someone walking by would have viewed it. The you at a funeral, to put it bluntly, Your Honor, there's only one dead Marine in attendance at this funeral. A reasonable person would know, would assume that they were talking about the deceased within the church. And those are the facts a jury can use to make these kinds of content-neutral conclusions.
Thank you, Counsel.
For the foregoing reasons, petitioner respectfully requests that you reinstate the trial jury's verdict of $3 million.
Thank you. Counsel, you may be heard.
Mr. Chief Justice, may it please the Court. My name is Suzanne Peters, and I represent Andrew Finicum, Victoria Finicum Corder, Rebecca Finicum Clinton, and Sidney Lewis Church of God, respondents in this matter. Your Honors, respondents respectfully request that this honorable court affirm the decision of the 12th Circuit.
Well, then why is the plaintiff in this case a public figure?
Respondents are not contending that a petitioner in this case is a public figure. Respondents believe that petitioner in this case was a private figure. However, when it comes to an IIED claim, the public-private distinctions respondents contend does not matter. In terms of the Gertz case, in which did state a public-private figure distinction, that was a defamation case. And defamation cases are different than IIED cases. The state's interest in that case is very different. The value of speech at issue is different than what is here today.
Counsel, before we go too far, I thought before we begin this whole line of cases in New York Times versus Sullivan, the Supreme Court expressly said, we don't care what the state calls it, we care about the impact. Didn't they say those very words?
Yes, they did, Your Honor. However,
does that defeat the argument you just made?
No, Your Honor. Respondents contend that even though it doesn't matter in terms of whether it's a defamation case or an IIED case, in terms of the private-public distinction, the reason for that distinction that Gertz said was that a private figure is more vulnerable than a public person. And in that case, a public person has access to the media, and a public person can remedy the wrongs that have been targeted towards them. Respondents contend that in an IIED claim, this access to the media is not as important. There are no false statements to correct, and it does not matter in that case. And respondents contend that in terms of whether a plaintiff is a public or private distinction, it does not matter in terms of the actual malice standard. Petitioners today are arguing that the outrageousness standard is a high enough standard. Respondents respectfully disagree. This court has specifically stated in Hustler magazine against Falwell that the outrageousness standard is no standard. When it comes to public discourse and social discourse, it allows a jury to impose their personal beliefs in terms of making a decision. It has inherent subjectiveness about it. And respondents contend that this actual malice standard must be in place in order to replace this very subjective outrageousness standard.
Well, why does it make any difference as to act, if it's an intentional infliction of emotional distress, the falsity of the truth of it, what's the rub? It's the intentional infliction. So why do you have to even have an actual malice? Why does falsity or truth even enter into the equation?
Well, this court actually addressed that exact concern in Hustler magazine against Falwell, and it stated Jerry Falwell in that case was very vigorously stating that it is the intent to cause the emotional harm, it is the intent that matters. And the court in that case said that this intent argument should not receive that much solicitude. The court specifically stated that we cannot risk chilling public debate because someone might be put on trial because their intent...
But what's the public debate? Are you now saying that this soldier is a public figure from that standpoint? Or that the obituary that was in the paper made him a public figure?
No,
or it's a matter of public concern because he was in the military? What's your position?
Respondents contend that this was a matter of public concern. Their science, the majority of their science address issues that are very, very popular in the public realm today. Those are homosexuality, homosexuals in the military, and American military policy in general. And so the majority of respondent science were of public concern. Respondents do concede that two signs, as petitioner pointed out, were more specific. Vernon held Andrew, and Andrew drove a gay car. However, this court has stated that when determining whether matters are of public concern, one must look to the context, the form, and the content. And respondents contend that these two particular signs, the content of them, cannot be divorced from the context.
So any person serving in the military, automatically, whether you agree or you disagree with the fact that there is a war going on, that automatically makes it a matter of public concern?
Respondents chose this funeral because it did involve a military figure, yes. However, respondents believe that this would be the most effective way for them to get their religious beliefs out into the realm of public discourse and invite comment on it.
They chose this funeral because they believed that it would be the best chance for them to get their religious beliefs, which they believe strongly, out into the realm of public discourse and invite comment on it. So it's not that going to a funeral of a military person makes it a matter of...
Where do you draw the line then? Or is there the capability of drawing the line in the matters of the First Amendment?
There is a chance to draw a line in terms of the First Amendment. However, what is lacking in this case is any type of statute which would have put respondents...
Well, what I want you to do is, if you say there is, give us an example.
An example of where the line would be drawn would be if respondents attended petitioner's son's funeral, had one sign that said America's hates fags, which is one of their signs, and had the remaining 7 of them specific towards Lance Corporal Keatley. That would be the line in respondents' belief.
So in this case, you had the 2 signs that specifically were addressed at Andrew. Does that meet the test that you just explained to us?
Respondents believe that those 2 signs, when a reasonable, prudent passerby would walk by the street and would see the context of what respondents were doing, the context of it was a matter of public concern. Those particular signs contained rhetorical hyperbole. They were very loose, they were figurative, and a reasonably prudent person walking on the street would not interpret them to be facts. They would.
And Andrew's not a figment of anybody's imagination, and particularly to the family.
That is.
So how can you say that as to the family, though, that would be hyperbole?
Based on what was said in that case, Andrew drives a gay car. This court specifically stated in Hustler magazine against Fowl, which statements that cannot reasonably be interpreted as true or facts and contain rhetorical hyperbole are very important to the realm of public debate, because we do not want public debate to suffer for lack of rhetorical hyperbole or lack of imaginative expression.
Counsel, I think go ahead.
The Court of Appeals said that they did not assert provable facts, and that's what you're talking about. Don't your clients believe that those signs assert provable facts?
Yes, Your Honor, respondents do believe that. However, even because someone might believe someone so strongly does not mean that it is fact. And respondents are arguing that a reasonably prudent person on the street passing by these signs would believe that what they were saying was a matter of public discourse and was a matter of public concern. And thus, because it is a matter of public concern, it is protected by the First Amendment.
Do you believe that any of the signs assert provable facts?
Respectfully, Your Honor, respondents do not believe that any of them assert
But
provable
they
facts.
do. You told me they actually do believe that. But do you, as their counsel here arguing, you believe that none of them assert provable facts?
I believe that those are their religious beliefs, and one cannot prove someone else's religious beliefs as to be true or not. Someone cannot prove whether Andrew is burning in hell. Someone cannot prove whether God condemns homosexuals. And so while it might there be beliefs, as a third party, someone is not in the position to be capable of evaluating whether someone's beliefs are true or not.
So you have a litigation position different than what your clients really believe.
Yes, Your Honor.
Okay, that seems very odd. But what I'd like to pursue with you is a different. If this funeral had been held at Andrew's home, do you agree there could not be pickets across the street doing exactly what they did?
Based on the standards set forth in Frisbee against Schultz, this court has specifically stated that a home is unique and that someone cannot target picketing towards a home.
Okay, so you couldn't do it at home. And suppose that it were held in a neighbor's home. What about that? Frisbees would still apply, don't you think? I'll short circuit our discussion.
I believe that in terms of what the Supreme Court was saying is that the home is unique, yes.
And residential areas are unique.
That is correct, Your
Why shouldn't we extend that to the, we say church home, it's your home church, it's where you came from. Why shouldn't we simply extend that to churches? This is an easy case. Why not do that? After all, your people are religious, they like churches.
In terms of answering your question, Your Honor, this court has been particularly reluctant to extend the captive audience doctrine outside the home. When it has done so, in terms of what petitioner pointed out in Hill against Colorado, in a healthcare facility, the court was particularly vigilant to state that what they were doing was not banning any type of picketing whatsoever outside the medical facility in Hill against Colorado. They were specifically stating that you cannot sidewalk counsel, you cannot approach someone, you cannot impede their access into the healthcare facility. The court specifically stated that, and they wanted to make it very clear that what they were doing was not saying that you can't stand 100 feet with signs and yell. You are still free to do that, but you cannot come within 8 feet of someone and inhibit their ability to enter that healthcare facility.
Do you think we should revisit that precedent?
Respectfully, Your Honor, respondents would argue no, and the reason for that is that this court has stated that oftentimes people are captive once they leave their house, and people often have to deal with offensive speech. And if this court had to then reevaluate it and come up to a point where they would have to list every place where someone might have to have a privacy interest, it would not be practical and it would not be an efficient manner.
No, I'm asking, what if we just said that was wrong, we should not have ever extended it beyond the home? And that the home should be the only place where you can't be target picketed, and any public place you can be. Would you be in favor of us changing our precedent in that way?
Respondents contend that the court did have a good reason in Hill against Colorado and Madison against Women's Health Center, and that is that in those cases, the parties involved were trying to enter a healthcare facility and seek healthcare access. And so,
Counsel, let's be plain here. They were exercising their constitutional rights, right?
yes, Your Honor.
Okay, well, why doesn't that apply here?
In this case, we're not saying that petitioners in this case do not have a constitutional right in terms of being in this church. What respondents are arguing in this case is that the statute in which petitioners are relying on, the intrusion upon seclusion statute, did not put anybody on notice as to what they could and could not be doing. It was overly broad, it was impermissibly vague. Someone does not know. Petitioner stated today that if they were not in sight, but they could still be hearing chanting, well then they would still technically be here today. How is someone to know that based on looking at the statute? One does not know whether they can stand 100 feet away and chant softly, stand 200 feet away and chant loudly. People are not aware in this case. And so the state does have an interest in protecting the constitutional rights of the petitioner. However, if the state wants to do it, it has to do it in a much more narrowly tailored fashion. This court has addressed this issue in Cohen against California, where the standard was offensive, as it is in this case. And this court specifically stated that, does this offensive standard allow someone to know that what might be permissible speech in one location is not permissible in another? And the court stated that this offensive standard does not put someone on notice. And respondents contend that this is exactly what is going on in this case. If respondents could stand in the public square and do this, but not here, how are they supposed to know that? If the state does want to regulate funerals and does want to protect this privacy interest of petitioners, the state must do so in a more narrowly tailored fashion than it did. It cannot use a tort of intrusion upon seclusion to achieve that goal. In terms of the actual malice standard, respondents would like to return to that. The respondents believe that the actual malice standard really should apply in this case because it is an objective standard, and it assures that a person can still bring an IIED claim, but it also ensures that a person will not be brought into the court because they were expressing their religious and political beliefs. If we're allowed to have this outrageousness, subjective standard that petitioners are alleging, it will chill public debate. People will be afraid that they'll be brought into court because their speech was of the minority and it caused offense to someone. And someone thought it was outrageous because it was in the minority, and it would completely chill public debate and completely eviscerate the First Amendment. Respondents do concede that their speech was offensive. However, this court has specifically stated that when speech is offensive, it warrants even higher level of constitutional protection. Respondents argue that they would not be here today if they were chanting signs like, "We love Andrew," "Rest in peace, Andrew," "God loves military." We would not be here today. This is all based on the content of what respondents said. And a state cannot be content-based in their applications of statutes, and this is exactly what is going on in this case. Respondents also do concede today that not all speech is protected. There is this fighting words doctrine that this court has specifically stated as an exception. However, the fighting words doctrine is not applicable in this case. The fighting words doctrine is when words are stated purely because when they're being stated, it rises to a breach of the peace. In this case, this is not what happened. There was no sense that there would be a breach of the peace. There was no direct provocation. Respondents didn't even approach petitioner in this case.
Hey, counsel, if your group has the right, another group has the right to come right beside them, right?
Yes,
And chant something against your group, right?
Yes, Your
Will
Honor.
we quickly have a place where Chaplinsky will apply and we can do something about this?
Yes, Your Honor. If someone says something to someone that rises to the level of Chaplinsky and the fighting words doctrine, it could be there today. However, this is not what happened in this case, and this court has been particularly reluctant to apply the fighting words doctrine since it did so in Chaplinsky. It would take a much greater threat to the breach to the peaceful
Two
atmosphere.
groups fighting each other on the sidewalks across from a funeral.
Yes.
Is that enough?
Simply, Your Honor, respondents would contend that the speech would have to rise to the level that just by merely being said, it was to incite a breach of the peace. So it would depend on the facts of what was actually going on. But if a statement is so offensive that by being said, it merely compels someone to want to engage into a fight, then yes, respondents would contend that if that was the facts of the case, then it would rise to the fighting.
Does it have to be something that's said, or cannot signs be so content hateful that they can incite a breach of peace?
It potentially could be, Your Honor. However, this...
Potentially. Let's say what you can say that's the most outrageous thing that you can possibly think of, if you put it on paper and hold the paper up, is it nonetheless speech?
Respondents are reluctant to agree to that, specifically because this court has stated that when someone burns a flag, which is a very offensive and could incite a breach of this peace, the court has stated the fighting words doctrine in that case does not apply. So in terms of whether putting a very offensive statement on a flag would rise to this level, respondents would argue that that probably also would not be a fighting words doctrine case.
So you think that it has to be spoken? It cannot be in the form of a sign?
It would have to be a very outrageous, very hurtful, very type of sign that would rise to someone to breach the peace, would be respondent's answer to that.
How about a picture? We're using words. We're very literal lawyers. What about pictures that are shoved in people's faces? You know the kind of pictures that are held up in these kind of cases.
Your Honor, my time has expired. May I briefly answer your question and conclude? Okay. In terms of the picture, again, respondents would argue that if this court has stated that burning a flag does not rise to the level, then a picture like the word on a poster would have to be have a very offensive type of nature. For the reasons stated today and in respondents' briefs, respondent respectfully requests that this honorable court affirm the decision of the 12th Circuit. Thank you.
I would inquire, is there any rebuttal time left? Yes. All right. Proceed, counsel.
Thank you, Mr. Chief Justice, and may it please the court. I have 3 issues I'd like to bring up on rebuttal. 1, the respondent noted that one aspect of the Gertz definition of a public figure is not implicated here, and that's true. It's the aspect that gives a public figure access to the media to correct falsity. That's not an issue here, but the second aspect of the Gertz definition is what implicates the state's weightier interest, and that is whether someone thrusts himself out into public discourse and then needs to be able to expect a certain amount of comment in their lives. The petitioner never did that and never could have expected this kind of comment and never put himself in a position to influence public debate.
Well, could a bride who has published the fact that she's getting married and the time and the place and with the picture and everything, hoping that it engenders, kind comments about how lovely the bride is, does that make it a public figure?
The petitioner would caution the court from finding that any bride who posts a bridal announcement would become a public figure for the same reason we caution against finding anyone who posts an obituary to then become a public figure, in that it would essentially draft millions of people across this country every day into being public figures. The second issue I'd like to rebut on is the content neutrality of the statute. The petitioner contends we would not be here today if there were signs that said, Andrew drove a great car, or that kind of thing. However, we very well still could be here today. The content of the speech is not what's at issue. These statutes do not regulate content. They regulate conduct. And the conduct here was a protest.
So you're saying you'd sue anyway? You would sue anyway if they put Andrew drove a great car?
Looking at the entire context of the funeral, what the other signs were, even if they were positive signs, if they were screaming a positive message that still could be heard from the church, that you couldn't hear the eulogy over it, certainly the intrusion upon seclusion claim still would be implicated.
Okay, so if they said, thank you, Andrew, for your tremendous service to our country. We love you. You are going to heaven straight away. The opposite of what these signs said. You're saying your client would still get $3 million.
It would be up to a jury to look at the entire context of that situation. What they're saying doesn't matter. It's how they choose to comport themselves as the respondents are saying it, looking at the time, the place, and the manner of that speech.
So you're just talking about how the person feels when they hear it, and that's entirely subjective based upon the grieving family member.
Your Honor, my time has expired. May I briefly answer your question?
Please do.
It's not about what the petitioner feels. He must show a physical manifestation of an emotional harm, but it's not about what he feels. It's about someone objectively viewing the entire context of the funeral and looking at it, looking at how they chose to write their signs, how they chose to scream, that kind of thing. That's what the jury is looking at, and the jury has plenty of information as a high enough standard to make a content-neutral determination as to the petitioner's claims. Thank you. For the foregoing reasons, we respectfully request that you reinstate the trial jury's $3 million verdict for the petition.
Thank you very much. The court will be in recess, subject to call.
Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
Please be seated. The court will proceed with case number 10, 1985. At this time, counsel for the petitioner will hear you. You may proceed.
Mr. Chief Justice, and may it please the Court, my name is Stephen Harkins, and I represent Ben Keatley, petitioner in this matter. I respectfully request to reserve 2 minutes of my time for rebuttal.
That's up to you.
Your Honors, this case is about the right of the state to protect its citizens. Recognizing the greater need to protect private individuals from tortious conduct, the District Court correctly declined to require a showing of actual malice to sustain an action for intentional infliction of emotional distress brought by a private person. Furthermore, under the precedents of this Court, South Virginia's intrusion upon seclusion statute is a properly constructed limitation on speech and conduct. Turning first to the claim for intentional infliction of emotional distress. Your Honors, this is a case that presents no direct factual predicate for the Court to apply. In Gertz against Robert Welch, though the claim was brought by a private individual, the underlying suit was for defamation, not intentional infliction of emotional distress. Similarly, in Hustler against Falwell, while that case did involve an intentional infliction of emotional distress, the plaintiff in that case was a public figure. In determining which rationale the Court should use and apply to this case, petitioners propose that the underlying factors important to the Court in those two decisions suggest that in the case for intentional infliction of emotional distress, action brought by a private individual, the actual malice standard should not be required. Rather, that standard should be applied only when the intentional infliction of emotional distress is brought by a public figure. There are two factors that were important in both Gertz and Hustler that lead the petitioners to submit so to the Court. The first of these.
So you're separating public figure from public comment as far as that. You're saying that in one instance there's no need, and in the other instance there is a need. But what if you reverse the two? What if the person is not? What if the person is not speaking about something involving public matters?
Go ahead. Sorry, Your Honor. If the individual is not speaking in something that is a matter of public concern, obviously the private figure might. Obviously the public figure might have a much greater interest, and thus the state might have a much greater interest in providing that individual recovery through tort. If the specific speech that is allegedly tortious and directed at a public figure does not implicate either matters of public concern or a matter of public concern that public figure has, by his unilateral action, inserted himself into for the purpose of enacting change or having a platform on which to speak about that issue. For instance, a direct harassment case, malicious statements directly targeting specific and very, very personal aspects of that public figure, then perhaps the actual malice standard should not apply. However, in this case, where we're determining whether, or it's asked to determine whether a private figure bringing a claim for intentional infliction of emotional distress.
Why shouldn't it apply? Because the courts talk about you don't want to have the jury being able to apply a subjective intent. And even in the private matter, you still have the jury being able to do that.
Your Honor, in this area, the court is attempting to balance very difficult issues, both of which have weighty constitutional concerns. The interest in the speaker in exercising his First Amendment rights against the interest in the state in protecting the privacy rights of its own citizens.
Well, Counselor, there sometimes we just ought to say that we care so much about the First Amendment we have to draw a firm line. And I think that's what the Court of Appeals was trying to do when it talks about the Milkovich case and says there are certain types of speech that cannot reasonably be interpreted as stating actual facts, and those have to be safe.
Well, Your Honor, while the court in Milkovich did identify petitioners contend correctly that certain speech, when sufficiently loose or hyperbolic, might be entitled to greater levels of First Amendment protection. The Milkovich decision, again, involved an action for defamation. And here, with the intentional infliction of emotional distress statute, it's not directly analogous.
Well, Counselor, aren't you building your argument on terrible sands, though? Because at the end of the New York Times versus Sullivan case, the Supreme Court says plainly, we don't care what the state courts call their torts. We're looking at their effect on the First Amendment. Don't they use those very words? at the end of the case?
Yes, Your Honor.
And doesn't that defeat the arguments you've made so far?
Your Honor, in interpreting which standard should apply for the intentional infliction of emotional distress, petitioners submit that in order to properly preserve the ability of speakers to engage in public discourse and to have that public discourse not be unnecessarily infringed upon by state tort law, the line the petitioners propose this court draw, not requiring a showing of actual malice for private individuals, would effectuate that. For example, an individual speaking generally about a matter of public concern is obviously entitled to the highest level of First Amendment protection. An individual directing their speech in relation to matters of public concern at a properly determined public figure may even engage in tortious conduct, so long as that conduct is couched in appropriately loose and hyperbolic terms. Further extending that protection, however, further extending the protection of the actual malice standard for the alleged tortfeasor in this case to actions that tortiously infringe on the rights of private individuals adds very little to the public discourse. There are already ample alternative means for speakers in those first two instances to bring their message into the public arena. And the privacy rights and the privacy interests of those private individuals who have not entered into public life are then unnecessarily infringed upon with only a minimal increase in the value of public debate and public discourse that rule would employ.
Does falsity have any place at all in regards to infliction of emotional distress, intentional infliction of emotional distress?
Your Honors, petitioners submit that this court's articulated test in Milkovich for determining whether or not actual facts exist should properly be applied to determine whether or not the actual malice standard is met. As the circuit court properly identified the importance of that test, petitioners simply contend that they over-applied it to this action for intentional infliction of emotional distress brought by a private individual. However, the falsity of statements, once it's determined that the actual malice standard needs to be met, could certainly be determined by looking at the actual facts test for Milkovich. A court reviewing an action brought by a public figure would use that test to determine whether or not the allegedly tortious statements contain facts susceptible to being proven true or false. If that were the case, then only in that sense, and when the public individual had made that higher showing at the court, would they be entitled to recover under state tort law.
Are you entitled to recover on your intrusion for seclusion claim, even if we hold the actual malice applies in the ID context?
Your Honor, the intrusion upon seclusion claim petitioner submitted is properly analyzed in reference to this court's articulated test in Ward against Rock against Racism for specific time, content, and manner limitations on content-neutral speech. Under the three-pronged test that the court held was necessarily needed to be satisfied in order to hold the statute sufficient, there must be in support of legitimate governmental interest, narrowly tailored, and must leave open ample alternative means of communication.
Was the jury verdict for that too? And are you entitled to recover on that claim? Is that a separate claim which you could base your recovery verdict?
Your Honor, the intrusion upon seclusion statute necessarily requires that something more than mere pure speech be involved. Here, had the respondents not managed to have their demonstration infringe on the seclusion and the legitimate personal privacy interests of the funeral goers and petitioner in this case, then they would not have satisfied the language of that statute.
So is the answer no or yes?
Yes, Your Honor.
You do think that you would still win?
Yes, Your Honor.
Even if IED requires actual malice?
If the intentional infliction of emotional distress claim requires actual malice, petitioners submit that the purpose of that test there is to appropriately protect this type of speech in the public discourse that we do not want that need not be unnecessarily infringed upon by state tort law. The claim for intrusion upon seclusion here does not deal specifically with pure speech. It is of a different nature that petitioners submit actual malice need not be proven in order to satisfy a claim under. In this case, the legitimate governmental interest at stake is the interest in protecting the sanctity and solemnity of funerals and burial rights. The state certainly has a legitimate interest in protecting individuals engaged in this activity, as this court has recognized in Favish against National Archives Association. Furthermore, the ample alternative means communication prong of such a test for determining the validity of that statute, by looking to the myriad other circumstances in which respondents would have been able to freely engage in the type of speech at issue without falling within the ambit of this statute, it becomes obvious that ample alternative means do exist.
What were they?
The respondents could have held their demonstration at a slightly different location. respondents could have held their demonstration even at the identical location and in an identical manner in which they did, and not have fallen within the intentional intrusion upon seclusion statute, so long as they had not chosen that location out of a desire specifically to intrude upon.
How do you know that they're protesting this funeral then? I mean, they could have gone off into the park.
And, Your Honor, that would have been a factual matter to be determined at the circuit court. And petitioners submit that had it been mere happenstance that respondents wound up directly across from St. Roddy's Church on that day.
Okay. Do you agree that the people in this instance had a constitutional right to stand on the sidewalk across the street from the funeral, just to be there?
Yes, sir.
So you have the right to say that they... Now, did they have the right, let's say, to stand there and sing songs?
Yes, Your Honor.
All right. Did they have the right to stand there and hold up the placard? I'm not telling you what kind of placard. I'm just saying, did they have the right to do that?
So long as the placards that they're holding and the songs that they're singing do not meet the terms of this statute, which require an intentional intrusion upon the specifically delineated seclusion of another individual. If those...
Let's say that if the placard says that, and this is let's say that it is a religious ceremony involving the fact that a person has died. What happens if the placard says the world is ending tomorrow? Is that all right?
Your Honor, the fact that that placard would be very unlikely, taken as a whole, looking at the context of the speech, the demonstration, and the expression at issue, to have intruded into one of the areas where petitioners are entitled to recover under the intrusion upon seclusion statute, here being within their private affairs of concerns, a captive audience within the church.
All those who read this sign are going to hell. Would that be perfectly all right across the street from the funeral?
Well, Your Honor, that sign, while not violating the intrusion upon seclusion statute, is very similar to signs that respondents could have displayed and not fallen into violation of that statute in this case. However, if the number of signs that they were displaying, if the volume with which they were chanting in regard to the message on those signs, and if the general tenor and context of the demonstration was such that it was clear their activity would intrude upon the solemn occasion of that funeral occurring within the church, and those individuals had directed and specifically targeted that solemn occasion to disrupt that occasion with their speech, the content of the signs, being that this is a content-neutral restriction, does not necessarily matter. What matters is the conduct of the respondents in taking their message, whatever that message may be, and infringing upon the personal privacy rights of the petitioner and other funeral goers in this instance in a way that made it impossible for them to enjoy their equally important rights in personal privacy. Your Honors, for these and the foregoing reasons, petitioner respectfully requests that this Court vacate the judgment of the 12th Circuit Court of Appeals and reinstate the judgment of the South Virginia District Court. Thank you for your time.
Thank you, counsel. Counsel for the respondent, we'll hear you. You may proceed, counsel.
Mr. Chief Justice, and may it please the Court, Your Honors, my name is Jacob Triolo, and I represent the respondents in this case. Your Honors, if there is one overarching principle of the First Amendment, it's the government cannot prohibit expression simply because that expression is found to be offensive. While it is true that states have the right to protect their citizens from wrongful injury, even injury caused by speech, that right has been justifiably limited when the speech in question is related to a matter of public concern.
Okay, counsel, let's just assume for a moment that the panel decides that the plaintiff in this instance was a private figure. Why should Falwell then apply?
Your Honor, the respondent doesn't believe that this matter hinges on whether or not the petitioner was a private or public figure. Rather,
my question is not whether you believe that it is. If the panel should decide that it is that he is a private figure, why should Falwell apply?
Because Falwell relates not only to private figures but also to public issues, and the matter before this Court today is a matter of public concern, one of political concern, and the respondent would contend that the Hustler decision. And
that is, what is the public concern in this case?
The public concern, Your Honor, the speech at issue is public in every sense. It's about a publicly funded war, and with publicly funded soldiers dying at that war, and the respondent would contend that the publicly funded war is caused by this nation's very public decisions on homosexuality.
What is the type of car that he drives? How is that a matter of public concern?
Your Honor, this court in Dun & Bradstreet versus against Green Moss held that when determining whether speech was public, the court has to look at the context, content, and form of that speech. And Your Honor, the respondent would note that that particular sign was one in which the respondent was trying to explain a larger public policy regarding his distaste for this government's beliefs on homosexuality.
What does that have to do with the government at all?
It's simply a statement by the respondent in order to highlight a larger political issue. And the respondent is using that speech, using that particular sign in order to bring light to his very public concern.
So it's your position then that everyone who is in the military results in the people being able to talk about a public matter or to voice public concerns?
Your Honor, yes, the general concept behind the ability for the respondent to speak on a matter of public concern has to do simply with his decision to bring a public matter up. The respondent's speech was not directed at the petitioner. The respondent's speech was not directed specifically at the funeral. Rather, the respondent's speech was a broader speech using that particular platform in order to get his political and his religious message out to a broader audience.
If it's not directed towards him, why does it have his name on it?
Your Honor, again, it's simply the context of the speech was meant to be controversial. And the respondent used that particular message in order to bring light to his issue. However, as this court has found in a number of cases, the respondent's speech was not something that was a provable fact about the respondent, or about the petitioner, excuse me. And again, while it did directly relate to his name, it was a broader picture that the respondent was trying to paint.
Well, why does falsity then have anything to do with intentional infliction of emotional distress? The fact that it can be the most outrageous, the biggest lie in the world, but if the intent was to inflict, then falsity of truth is irrelevant, isn't it?
Your Honor, the falsity of truth would not be entirely irrelevant because that would potentially bring the respondent into a defamatory state. And in this instance, where we're looking at an IIED claim, the court has held that citizens will have to deal with outrageous and offensive speech. So the falsity is still important, but that's a trigger that could potentially pull the respondent into discussing a defamatory issue, which would then put him under a different set of precedent by this court. So yes, it is still important.
But falsity, in a First Amendment context, the burden is on, in this case, the petitioner, as I recall. Whereas if it's a true First Amendment case, but under the state's right, if they have the right to do an intentional infliction statute is what we're dealing with here, then falsity or truth has nothing to do with that. It's the intent to outrageously inflame the people that are in front of them. I mean, the fact that it's true or false when it's intentional has nothing to do with it. Isn't that right?
Your Honor, the falsity portion of the Falwell decision was simply creating it was the court acknowledging that speech on matters of IIED-related matters receives the highest echelon of protection by this court. And it's simply creating a platform that would have to eventually be met in order for somebody to be liable under that particular.
But they also say that there are those instances where you would be liable.
Yes, Your Honor. The court does specifically bring up that there's certain outrageous misconduct.
Can you give us an example then under your theory where it would be permissible and it would be able to sustain this type of action?
Yes, Your Honor. The court specifically brings up in the Falwell or in the Hustler decision that statements that turn into fighting words would be something that an IID claim could limit the respondent's First Amendment rights. However, in this case, and then that was the main point.
But that was a case involving a public figure with public concerns, wasn't it? This is not a case of public figures and public concern.
Well, Your Honor, the respondent would contend that the general concept behind affording public figures a less level, something that a public figure is speaking against a higher level of protection than a private figure is one that this court brings up in the Gertz case. However, this court specifically says that in relation to that higher level of standard, it's for an individual, private individual, who is defamed and that would give them the ability to, they don't have the ability to redress that defamation.
Counsel, let me change the focus of the argument for a second. Do you agree if the funeral had been held at home that your clients lose if they tried to take it across the street?
Your Honor, the court held in Frisbee against Schultz that there, in terms of intrusion upon seclusion claim, that in front of a home was protected.
Why, we talk about homes as being your church home or where you grew up, that sort of thing. Why shouldn't we just simply extend that doctrine to churches?
Well, Your Honor, in terms of extending the doctrine to churches, the one issue in relation to the respondent's speech is the respondent was never given warning that standing out in front of the church would limit his constitutional rights. This court has held in Miller against California, and while those facts weren't analogous to this case, the court has held that if a person is going to have their first or any constitutional right inhibited, they must be given warning prior to being fined.
In this case, were they in fact told that they could expressly stand where they were standing and that they could protest there?
Yes, Your Honor. The respondent, prior to coming to South Virginia and conducting this protest, contacted the South Virginia, the local police.
So that's different than Frisbee and Hill?
Yes, Your Honor. And specifically, in Hill against Colorado, this court held that a narrowly tailored statute was necessary, and this court upheld that narrowly tailored statute because it limited the speakers in that instance from essentially forming a gauntlet of protests.
So can we make a rule going forward that the police can tell you that you have to leave in front of a church and that we're going to protect a church just like we protect a health center?
Your Honor, it was that idea would still necessitate, according as the respondent understands this court's interpretation of the intrusion upon seclusion claim, a statute that would inform the respondent beforehand that what he or she was doing was potentially going to limit their First Amendment rights.
Do you lose this case on either tort theory, or do you have to win both tort theories, or if you knock out one of them, you've won the whole case?
Your Honor, the tort theories are very separate from each other, and
so can the verdict be sustained under intrusion and seclusion? You have to win both to keep your case?
No, Your Honor. The two different tort claims could be held separately. However, the broader concept behind the respondent's claim is this court has held again and again that outrageous offensive comments are protected by the First Amendment of the Constitution so long as they are related to matters of public concern. Therefore, the respondent would argue that under that concept, he would not be tortiously liable under any statute, or under either of these statutes, excuse me. But they could be held separately, yes.
The jury awarded damages on each claim?
Yes, sir.
Who determines public concern?
Your Honor, again, the court held in Dun & Bradstreet that it's something the court determines, and the court looks at the context and form of the speech. And so in this instance, it will be the court that makes that determination. However, Your Honor, the respondent would also state that in Hustler, this court also brought up, separate from public issues, that the court protects First Amendment rights if the statements made by a speaker are based on political discourse. So even if the court was to find that this wasn't specifically public speech, the respondent was still involved in political discourse, and that still receives a heightened level of First Amendment protection, which would protect the speech under the IIED claim. Your Honor, the respondent would also like to briefly respond to the petitioner's comments regarding the Gertz case and how that standard should be applicable in this instance. In that case, the court very clearly held that it only extended so far as a defamation claim, and the reason being that private figures needed additional protection when a figure defamed them because they don't have the resources necessary to go out in the public and reclaim their good name. The idea that that case should be extended to private figures when it's just an IAD claim would simply limit the ability for political discourse for somebody involved in political discourse to ever be aware of when they were going to be held tortiously liable for a comment they made. In addition, under the Milkovich standard, this course further limited the Gertz holding and stated that when the speech in question is on opinion and of public concern, if it's hyperbolic or not provably false, that removes the ability for the courts, the state courts, to tortiously hold somebody liable under the previous Gertz standard. So the respondent would just like to bring that up and again urge that this court hold that the respondent's speech is protected under the Hustler standard. For the foregoing reasons, respondent asks this court affirm the 12th Circuit and hold that the respondent's speech is protected by the First Amendment of the United States Constitution. Thank you.
Thank you, counsel. Rebuttal time? We'll hear you, counsel.
Your Honors, I'd like to briefly address the respondent's contention that respondents in this case were not warned and had no notice that they might fall in violation of the statutes at issue here. In both of these statutes, there's a mens rea requirement. The mens rea requirement in the intentional intrusion upon seclusion statute is intentional. Respondents were made aware by their intentional decision to undertake the activity at issue here that they might potentially have an effect on the individuals who later on would claim tort judgment. The statutes that respondents were in compliance with by standing across the street and notifying the police officers there are criminal statutes. To enforce a tort claim, criminal liability simply need not attend.
But how did they know that they were too loud? How did they know they could be heard all the way inside the church? And then nobody comes out and says, hey guys, keep it down, we're trying to have a funeral here. How do they know that they're being offensive in that way?
Your Honor, the reasonable intent of the respondents in this case obviously was to have some effect on the funeral. The chanting in the manner that they did, which could be heard inside of the church, was of a sufficient volume that it becomes very...
I thought was to get on the news.
And Your Honor, while respondents have a right to seek a wide audience for their message, and while respondents' message is indeed entitled to significant protection under the First Amendment, what respondents are not entitled to do is to step on the rights of private individuals going about their private activity in a reasonable manner in order to attain that platform. Petitioners again repeat that for the foregoing reasons, this Court should vacate the judgment of the 12th Circuit Court of Appeals and reinstate the judgment of the South Virginia District Court.
Thank you, counsel. Your argument will be considered, and then the court is in recess.